The Community Disputes Management Framework, CDMF, was started in 2014 to facilitate effective resolutions and foster a more gracious and harmonious living environment for all Singaporeans. This bill brings in new and much-needed enhancements to the framework. I've been looking forward to this bill for some time. I support this bill, but I have some questions and concerns. First, on the CRU. Mr. Speaker, under this bill, a new Community Relations Unit, CRU, is being piloted to address a small minority of severe neighbour noise disputes and hoarding cases. I know that an experimental unit will start work in Tampines. Like Mr. Lim before me, can the Minister share some more details regarding the size of the initial team and what is the government's current plan to scale up from the initial team? When is the department expected to operate at a national level covering all constituencies? Just an estimate. On the score of matters to be covered by the CRU, Mr. Speaker, I'd like to seek some clarifications regarding the CRU. Firstly, I read in a Straits Times article dated 12 August 2024 that the CRU will only step in after neighbours have failed to resolve disputes among themselves, while at the same time the CRU officers will be able to issue directions for residents to go for mediation. May I clarify what is the requirement to determine that neighbours have failed to resolve disputes among themselves before residents can seek CRU's intervention? Is it a request by one resident for mediation at the CMC, which was rejected by the other resident, or a request to HDB to engage the neighbour, which was unsuccessful? May I also know whether the department has intentions to expand the scope of the disputes you will cover beyond noise and hoarding, and if so, what is the estimated timeline? Indisputably, noise nuisance is a very common cause of neighbours' dispute. However, there are many other types of disputes between neighbours. For example, disagreement over the placing of articles outside their homes, behavioural issues, smoking in one flat affecting another unit, etc. Next, some clarifications on the qualifications of CROs. The proposed Section 13C allows the Director General to appoint 3 types of personnel to be CROs. Community Relations Officers, 1 a police officer, 2 a public officer, and 3 an officer or employee of a statutory board. I find it odd that the criteria to be a CRO as listed in this bill is not by way of specified training or qualification, but as long as the person who holds one of the appointments specified. May I know what is the training which a public officer or an employee of a stat board needs to undertake to qualify as a CRO? Certainly, there's a whole range of public employees doing a whole range of work, from clerical, administrative, to operations across different types of agencies. So the criteria can be more clearly defined. I also note that the bill proposes to give powers to the CROs to carry out a number of stated duties, such as entering residences to collect evidence, issue advisories, notices, or orders, etc. Regarding entrance to residences, may I ask in what circumstances will officers enter homes to collect evidence without the need for consent from flat owners? While it's important that such entry, even without the owner's approval, is done judiciously and with due respect to the owner of the residence in question, on the other hand, requiring consent may in turn at times frustrate or delay entry, leading to removal of evidence of nuisance creation. So how will the authorities address such contending considerations? Next, on noise sensors. I hope the proposed deployment of noise sensors will greatly assist with the reduction of noise nuisance. Detection of noise and the identification of the actual source of noise are often not as straightforward as we imagine. A knocking noise that ostensibly comes from the direction of the flat above may well come from another flat or source and may have a different cause from what we imagine. During COVID, a persistent noise in the still hours of the night every day caused consternation among my residents from more than half the flats in a particular stack in a block in my constituency. Residents spoke to their neighbours above and below their flats. However, the source of noise remained inconclusive after many months, with some believing later that the sound had come from a unit to the right of the units affected. I hope the proposed noise sensors will help to improve certainty in the detection of noise and assist to eliminate or minimize noise that will cause friction between neighbours. Regarding the deployment of noise sensors by CRE officers, I know that consent is required of the owner of the affected unit. I wish to seek a clarification from the Minister whether the authorities expect the deployment of sensors to be within the complainant's flat or even in common corridors or other common areas. Will the authorities even deploy such sensors in a flat where the alleged source of noise is believed to come from? If so, is consent required by the owner, and what happens if the owner withholds consent? Currently, I often hear complaints from residents telling me that there are neighbors who stop making noises after they were spoken to by HDB or NEA, but after a while the noises will return. Likewise, we often see feedback or high-rise littering or feeding of birds resuming after a period of deployment of NEA's cameras following earlier complaints. Mr. Speaker, resources are often limited, and I'm not sure whether these noise sensors may be comparably limited in supply as, say, NEA's detection cameras for high-rise littering. And I hope the Minister will ensure that there are sufficient numbers of such sensors for use for different cases. How would the authorities deal with recalcitrants repeating their noise nuisance after the noise sensors have been taken off? What can be done to deter residents from playing so-called cat and mouse game? Mr. Speaker, after the first reading of the bill, an Hougang resident wrote to me highlighting his concerns that frequently before a party takes a dispute to mediation, they might not have suitable evidence of the noise complained of, and this would often hinder a successful or fairer mediation and resolution of the dispute. He suggested that the government should allow residents the option to have the use of noise sensors even before they proceed with mediation. I agree with this suggestion. Clearer evidence of nuisance will provide a more accurate and objective focus for parties and their mediators and enhance the resolution process at CMC and thereafter. May I clarify whether such pre-mediation access to noise sensors can be considered? Next, on tenanted units. Mr. Speaker, I welcome the new measures in this bill to handle noise nuisance arising from tenanted units. In many cases, there may be a number of tenants living within a unit. I have also in the past received feedback on noise issue from tenants. Noise arising from tenants who do shift work or work odd hours and return to their flat each day, late at night or early morning, or even getting up very early in the morning to go to work. To be fair, the tenants, whether local or foreign, who may be the subject of feedback, may be a small proportion of the total number of tenants. I sense that this is often due to a lack of understanding on the part of the tenants that they might have subconsciously generated noises which may seem louder, especially during the quiet hours of the night. Besides language barrier, there are sometimes practical communication difficulties trying to get through to these individuals when agency staff are often only at work during the usual office hours. Even apart from the new provisions, I always thought that HDB can also impose obligations on owners renting out their units by way of imposing appropriate covenants at the onset when tenancy is entered into and when owners are seeking permission from HDB to rent out their units. In this way, owners can be better made to understand their responsibilities in respect of their tenants, and tenants can also have a better understanding of what is expected of them, especially the issue of being considerate to their neighbors. In the worst scenario, of course, of non-cooperation, HDB can withdraw their permission for subletting. I next move to mediation. Mr. Speaker, in my speech at COS 2023, I called for mediation to be made compulsory. The rationale for my proposal in my speech at COS last year was that, and I quote, as mediation at CMC requires the agreed participation of both parties to a dispute, many such disputes do not stand a chance of being resolved by mediation simply because one of the parties opt out of mediation. I've observed from my own experience with residents' disputes that as residents know that mediation is not mandatory, many would deliberately not respond to mediation. Indeed, Mean Law shared in its paper in this bill on 24th August 2024 that less than 30% of total cases registered at the CMC proceed to mediation because one party does not wish to participate in mediation. I've also shared that notwithstanding that mediation may not always be suitable for every dispute, I have felt that for a good number of cases, it was a good opportunity wasted for parties to try and resolve their differences during mediation when parties have the option to opt out. Mr. Speaker, I'm therefore glad that the government will make mediation mandatory before one proceed with CDRT proceedings. The bill will also allow the CRU and the Community Mediation Centre to direct parties to attend mediation. However, the net can be cast wider to achieve more resolution if the requirement is not tethered to the commencement of CDRT proceedings. I say this because many residents are still reluctant to proceed to CDRT, due, among other reasons, to the formal requirements imposed. Mr. Speaker, this bill also allows consenting parties to register their mediated settlement agreement as a CDRT order. This will carry the same force and effect as an order of court. This is a good measure. I have spoken to residents who went to mediation at CMC, and notwithstanding what was agreed at mediation with their neighbours, there was still non-compliance in part or in full, rendering continuing frustrations and tensions between the feuding neighbours. Allowing mediated settlement terms to have the weight of an order of court will ensure greater compliance by both parties to the mediated settlement terms to ensure better and longer-term resolution of their disputes. Mr. Speaker, I have one other clarification. Regarding the proposed Section 20, which amends the current provision of the Act allowing the application for transferring of claims from CDRT to a court, may I take the opportunity to just clarify, Minister, in the case of such a transfer, will parties be allowed to appoint a lawyer to represent them, as is the case for normal state court proceedings? However, if it is allowed, would this potentially lead to any injustice, since parties are not allowed to engage counsel for CDRT cases, and especially if only one party is allowed to do so? Mr. Speaker, in Mandarin. 议长先生，目前邻居之间的纠纷需要居民到社区调解中心或到邻里纠纷审裁庭诉讼，但许多人不愿意这么做。我希望社区关系处的成立将会大大改善我们处理邻居纠纷的过程。我盼望丹宾尼的试点计划能尽快完成，更期望社区关系处的职责范围能扩大至噪音以家中等级杂物问题之外。我期盼这单位能尽快扩展到全新加坡，包括后港。我也支持在将案件提交邻里纠纷审裁庭之前，强制各方出席和解的修正。我曾在处理许多邻居纠纷中遇到各方如何回避出席和解，并我也曾在国会中提出过这个问题。我相信强制各方出席和解是一种解决问题的好机会。议长先生，我支持这项邻里纠纷解决修正法案。Mr. Speaker, in closing, I welcome the key changes in this bill, in particular setting up the CRU, which I hope will bring significant improvements in the way we currently manage disputes in the community. I look forward to the day the CRU will expand its operation to the rest of Singapore, including Hougang. Mr. Speaker, notwithstanding my questions and concerns, I support this bill.
Those of our residents who have long-standing neighbour disputes have been looking forward to this bill for a few years. In HDB estates, the usual route for dispute management has been to activate HDB or the Town Council, thereafter to recommend mediation. If mediation is not possible or does not succeed, then parties end up in court, namely the CDRT, where some residents end up frustrated and distressed when their cases were dismissed because they did not have the solid evidence that the court required. It is clear that the existing procedures are inadequate. So the bill is the culmination of the multi-year effort of several ministries and agencies, which must be duly acknowledged. It is also clear that the enhanced CDMF, or Community Dispute Management Framework, will be a resource-intensive exercise requiring standby teams after office hours and active management of difficult cases by the new Director General of Community Relations. The work will not be easy. As there are many MPs speaking on this bill, I will be succinct. There are three particular features of the bill which I find useful. First, there are avenues for quicker intervention on the ground. These avenues include measures such as the Director General of Community Relations issuing abatement orders and the CDRT being empowered to issue interim orders. These can be very useful when urgent action is needed to manage the ground situation. Secondly, noise sensors may be deployed at the complainant's premises or common areas to help determine the intensity and the source of a noise disturbance. On this, the MCCY has acknowledged in its August statement that, and I quote, "Sound recordings made by complainants are often not useful for the purpose of determining the volume, as playback can be distorted, or source of noise," unquote. SMS SimN touched on this point earlier as well. Several of my residents will be vindicated to hear this official acknowledgement that it was not their fault that they could not come up with the necessary evidence to prove their cases at the CDRT. Thirdly, greater responsibility will be placed on landlords to manage noisy tenants in the proposed Section 10A. Landlords may be required by the court to put up compliance bonds, where up to $20,000 may be forfeited if their tenants fail to comply with orders of the CDRT. Indeed, it is quite common to receive complaints of noise nuisance from units which are sublet. It seems fair to place more responsibility on landlords who are earning rental income when their neighbours suffer. That said, I would like to raise three queries about the bill and its implementation. These relate to the Community Relations Unit, CRU, the CDRT's processes, and HDB's increased powers. First, on the CRU. It is somewhat disappointing that the CRU, which will have powers of intervention on the ground, will only be activated in Tampines Town on a one-year pilot. Likewise, I have the same question as the others. Is there a timeline for the CRU to be rolled out nationwide? I can think of a few chronic cases in my ward where the CRU could potentially make a big difference, and a wait of several years will be hard to explain. A sub-question relating to the CRU is about its officers, from director to the ground. Will these persons be full-time and focus only on CRU work, or will they be double-hatting with other duties? Whether they are full-time or double-hatting will affect their capacity to work on dispute cases. Second, regarding CDRT processes. There is a significant change to the CDRT regime in Clause 21 of the bill regarding the award of costs in CDRT cases. Earlier, Minister Edwin Tong touched on this point. The current position is that costs will generally not be awarded to parties in CDRT cases. This non-award of costs makes sense, as parties generally present their own cases at the CDRT where lawyers are not allowed. Under Clause 21, this is being amended to generally permit the award of costs and disbursements in accordance with the rules of court. Could the Minister further elaborate on the rationale for this change? Will this change somehow allow, for example, a clawback of the costs incurred by the CRU to manage a case? More generally, I wonder what range of costs is being envisaged to be awarded and whether this will be punitive to the losing party. Finally, sir, my third query is about HDB's powers to compulsorily acquire a flat. Clause 36 of the bill proposes to enable HDB to compulsorily acquire a flat if the owner or an authorized occupier related to the owner is convicted of an abatement offence and has a prior record of another abatement or exclusion offence. I'm quite worried about the scenarios that could play out under this new power of HDB. Suppose, for instance, an adult child of a family has mental illness and shouts and bangs doors at odd hours, thereby interfering with the neighbours' peaceful enjoyment of their homes. It is foreseeable that the neighbours may take action and complain to the CRU, which then issues abatement orders to the household. If the required history of non-compliance is chalked up, HDB may be empowered to act under the new Section 63, subsection O of the Housing and Development Act to compulsorily acquire a flat. This is a drastic measure, as SMS acknowledged earlier. Given that compulsory acquisition will result in a below-market compensation being paid to the owners, how will the family move on from here? If their flat is still not fully paid up, the situation will be compounded. Will HDB assist them to find and afford their next home? Sir, clarity on the questions I've raised would be necessary. That said, I support the bill.
Tuan, usaha kementerian mempertikat dan memperketatkan Akta Huraian Pertikaian Masyarakat CDR dialalukan oleh ramai pihak dan masyarakat am. Saya serta Parti Pekerja menyokong pindaan orang undang-undang ini. Saya ingin mengajukan penjelasan dan mendapatkan pencerahan bagi beberapa perkara yang berkaitan dengan pindaan orang undang-undang ini. Pertama, salah satu usaha baru yang akan diadakan adalah penggunaan alat-alat sensor atau pemantauan bagi merakam bunyi-bunyian dan sebagainya, di mana ini mungkin akan digunakan sebagai bahan bukti di sesi tribunal. Perkara ini tertera pada seksyen baru 13H. Tuan, ini adalah satu inisiatif yang amat baik dan berguna, terutama bagi pemilik-pemilik rumah atau flat yang sudah berusia senja dan tidak mempunyai keupayaan dalam penggunaan alat-alat atau teknologi rakaman, terutama yang terbaru dan canggih. Namun saya ingin bertanyakan sama ada pihak tuan rumah akan dikenakan sebarang bayaran bagi penggunaan alat-alat ini. Saya bertanyakan demikian kerana ada golongan yang akan keberatan jika ada bayaran dikenakan atas sebab-sebab tertentu. Jika ada dikenakan bayaran, diminta agar diadakan pengecualian bagi golongan yang memerlukan. Tuan, seksyen baru 13C adalah tentang penumbuhan unit hubungan masyarakat atau Community Relations Unit, CRU, serta pemberian kuasa pada pegawai hubungan masyarakat yang dilantik. Penumbuhan unit hubungan masyarakat yang dengan diberi kuasa-kuasa tertentu adalah amat diperlukan. Awal tadi, Menteri Edwin Tong dan Menteri Kanan SIMN ada menerangkan tentang fungsi dan operasi unit hubungan masyarakat CRU. Saya ingin mendapatkan sedikit lagi pencerahan tentang cara unit hubungan masyarakat beroperasi. Harap dapat diterangkan sama ada unit hubungan masyarakat ini beroperasi sama seperti pihak polis, di mana masyarakat boleh hubungi unit ini pada bila-bila masa sahaja, pada lewat malam atau awal pagi, untuk mendapatkan bantuan dalam menghentikan gangguan yang datang dari pihak jiran pada ketika itu juga. Tuan, seterusnya saya ingin mendapatkan penjelasan tentang dua situasi yang sering berlaku sesama jiran di estet perumahan HDB. Adakah rang undang-undang ini atau akta yang sedia ada merangkumi kedua-dua situasi yang akan saya sebutkan. Yang pertama, saya percaya anggota-anggota Dewan ini serta pihak HDB sering didatangi dan dihubungi mengenai pembayaran ganti rugi bagi kes-kes kebocoran yang melibatkan kerosakan pada kabinet, perkakas dan alat dapur dan kos rawatan bagi kes-kes kecederaan yang berlaku pada penghuni flat yang disebabkan kelicinan lantai berpunca dari kebocoran siling dan paip yang disebabkan paip sumbat di rumah jiran tingkat atas. Beberapa kes yang diketengahkan pada saya adalah situasi di mana pihak HDB telah berkunjung dan menasihati jiran agar tidak menggunakan paip dapur di sinki dapur, namun nasihat tidak diindahkan pemilik rumah sehingga menyebabkan keadaan bocoran bertambah buruk dan mendatangkan lebih kerosakan pada harta benda jiran bawah. Saya fahami bahawa pihak HDB akan menasihatkan kepada penghuni flat yang terjejas untuk menghubungi jiran mereka dan minta ganti rugi bagi kerosakan yang berlaku atau kos perubatan. Tuan, harus diakui bukan mudah bagi pemilik flat yang terjejas untuk mendapat ganti rugi kerana ia hanya akan berlaku di atas kerelaan jiran mereka. Apa yang difahami dalam situasi di mana pihak jiran tidak setuju, pihak yang ingin mendapatkan ganti rugi perlu melakukan tuntutan sivil. Seperti yang diketahui, perkara yang sedemikian ini tidak boleh dibawa ke tribunal tuntutan kecil atau small claim tribunal. Tuan, saya ingin mendapatkan penjelasan sama ada dalam kes-kes sebegini, bolehkah pemilik flat yang terjejas menggunakan saluran CMC dan jika keadaan memerlukan, memfailkan kes mereka di CDRT. Saya berpandangan bahawa isu sedemikian yang melibatkan sesama jiran adalah lebih baik dikendalikan oleh CDRT atas dasar ianya membabitkan aspek dan unsur kejiranan dan kemasyarakatan. Tambahan pula, jika dibandingkan antara proses undang-undang CDRT dan tuntutan sivil, proses tuntutan sivil adalah lebih rumit dan mencabar. Satu lagi situasi yang saya anggap sebagai isu kejiranan adalah pertikaian antara pemilik peniaga yang mengendali perniagaan di unit-unit komersial yang terletak di bawah flat HDB yang selalunya terdapat pada blok flat 4 tingkat. Tuan, Seksyen 4, Subseksyen 4A dan 4B pada akta yang sedia ada saya nukil, a neighbour of a respondent is an individual who lawfully resides in a place of residence, A, that is in the same building as the respondent's place of residence, or B, that is within 100 meters of the respondent's place of residence. Berdasarkan penjelasan ini, akta ini tidak merangkumi situasi di mana berlakunya pertikaian di antara pemilik flat yang berjiran dengan pemilik atau penyewa sebuah unit komersial di blok yang sama yang dalam lingkungan 100 meter dari tempat kediaman responden. Saya ingin berkongsi situasi yang berlaku di kawasan undi saya di mana beberapa pemilik flat yang berjiran dengan sebuah unit komersial yang menjalankan perniagaan, pembuatan dan penjualan pastry dan kuih muih. Saya telah didatangi oleh beberapa pemilik rumah flat yang mengadu tentang kualiti kehidupan mereka terganggu oleh hawa panas, bau dan bunyi bising pada awal pagi yang datang dari sebuah unit komersial yang terletak di lantai bawah di blok yang sama. Aduan mereka telah saya salurkan kepada pihak HDB dan NA beberapa kali dalam jangka masa beberapa tahun. Yang terbaru, beberapa bulan yang lepas ini, saya telah didatangi oleh seorang pemilik rumah yang terjejas membuat aduan dan meminta bantuan agar sesuatu dapat dilakukan. Dia memberitahu saya beberapa jiran dia yang pernah membuat aduan telah berpindah ke kawasan lain kerana mereka lagi dapat menanggung penderitaan fizikal dan mental yang disebabkan hawa panas, bau dan bunyi bising yang dihasilkan oleh unit komersial tersebut. Tuan, dalam kes ini, walaupun aduan telah disalurkan pada agensi-agensi pemerintah yang relevan dan saya percaya langkah-langkah telah diambil oleh yang sebolehnya oleh agensi-agensi ini untuk mencari jalan keluar yang terbaik, namun apa yang saya fahami dari perkongsian pemilik flat yang datang berjumpa saya, perkara yang diadukan tidak mendapat penyelesaian yang baik sehingga ia menyebabkan beberapa pemilik flat berpindah ke kawasan lain demi menjaga kesihatan mereka dan keluarga mereka. Saya percaya kes yang baru saya kongsikan ini juga telah berlaku di estet-estet perumahan HDB yang lain. Di sini saya ingin mencadangkan agar pindaan pada akta CDR pada masa mendatang diperluaskan lagi dengan merangkumi juga unit-unit komersial yang terletak di blok-blok HDB, bukan hanya semata-mata unit-unit kediaman sahaja. Tuan, sebelum mengakhiri ucapan ini, saya ingin mengutarakan sebuah cadangan iaitu agar diadakan perintah untuk menghadiri sesi kaunseling wajib, mandatory counselling. Penyelesaian pada pertikaian di antara jiran-jiran melalui proses tribunal mungkin bukan sebuah penyelesaian yang kekal jika isu atau punca utama tidak ditangani. Isu-isu pertikaian selalunya bermula dari kurang kesedaran dan kefahaman tentang perlunya bersifat toleransi, hormat menghormati, bertimbang rasa dan cara komunikasi efektif dalam membincangkan sesuatu isu yang menjadi pertikaian. Dengan menghadiri sesi kaunseling, diharapkan dapat memupuk dan memperkuatkan lagi semangat kesepaduan dan kejiranan pada pihak-pihak yang menghadapi pertikaian. Sekian, terima kasih Tuan.